All right. So,
Well, great. Should we
yes.
start then maybe or?
Yeah, I'm just waiting for the recording to start.
Yeah.
And there we are. So, welcome to another workshop session at SUP46. And great to have Gabby and Olof here to talk about fundraising. Yeah, Olof and Gabby representing Fondia are legal partners, and they have an extreme in-depth understanding of the legal aspects of fundraising, term sheets, and everything in between. Gabby, Olof, welcome. And for the members arriving, Eric and Vanessa as well, welcome. Good to see you guys. Leaving the word to Olof and Gabby.
Thank you, Sebastian. Well, hello guys. My name is Gabriella and I work at Fondia, as Sebastian just mentioned. And at Fondia, I mainly work with all kinds of startup law. So it can be everything from investment to intellectual property law, but also employment law and privacy questions. So I'm a bit of a generalist. And over to you, Olof.
Thanks. Yeah, so I have basically the same profile as Gabriella. I work a bit more with incentive schemes, so maybe warrants or qualified employee stock options and those kind of things. But otherwise, it's investment law for me as well, mainly directed towards startups. Shall we just dive into the presentation, perhaps?
Yes, so basically today we are going to talk about different ways to raise equity and also a little bit about the paperwork behind raising equity. So what you as a startup must think about in connection with raising equity from a legal perspective. Then we are going also to provide you with some practical examples, taking into consideration the limited amount of time we have today. We won't be going into depth, but as you can see from the agenda, we have also some time for discussions and some time for you guys to ask questions as well. Let's dig in.
All right, so to start off with, there's of course not only one way to raise equity. Equity can be raised through certain procedures, and there's a number of ways to raise equity. And the most common one would be the first one, to issue shares. In other words, we're creating new shares and investors are paying for these shares. So the amount of shares in the company is increased. Then another way to raise equity is so-called a SAFE, and we're not going to go too much in depth here because it's not recommended to use this way in Sweden at least, but it means that an investor provides certain capital into the company, and given certain events, that capital may be converted into shares. All right. Warrants follows the same principle. Basically, you buy warrants in the company, and when you provide your capital, no debt is shown on the balance sheet because it's not a loan. It's equity that it's provided, and the investor has the right to, given a certain moment in the future, buy shares or convert that into shares, basically. And the last one is a convertible loan agreement, or to grant a company a convertible loan. So this is a debt on the balance sheet. It basically means that an investor grants the company a loan, and given a certain time, or most likely and more often a certain event, such as a new investment round, say 1 year from now, the investor who granted the loan gets to convert this loan into new shares, but with a discount when compared to the new investors. All right. So now Gabby will move forward with describing just shortly why a SAFE is not recommended to use in Sweden. You're muted.
I know. Thanks. During my time at Fondia and also before, I've been provided with several SAFE agreements. And my first reaction is always, don't use it. It's a very common way of raising equity under common law jurisdictions, but in Sweden, it's not really a good idea to use it. because it's a model adapted to US law. And also, what does this mean? It means that usually it's subject to the laws of the United States or other laws. And for those who have a company in Sweden, Swedish companies are always subject to the Swedish Companies Act, so aktiebolagslagen. It is mandatory and it is applicable to all companies registered in Sweden. In the Swedish Companies Act, there are several provisions that you must consider and that you can't agree to deviate from. Such provisions include the protection for minority shareholders. But in addition to that, the SAFE also implies several tax law implications that I will not be going into depth today, because that is, I could be talking about that for 3 hours. But in short, you can say that Swedish taxation law is complex, and you should always keep it in mind when drafting agreements or raising equity. And also, just as a short, brief note or comment, if you are provided with a SAFE by the investor, do not try to redraft it by yourself or ask a lawyer to redraft it. Do not, because usually from a cost and time perspective, it's usually more beneficial to actually just go ahead and draft an agreement that's customary under Swedish law. So then you might think, okay, so what are the alternatives to SAFE? And that Olof will be telling you about now. You're muted, Olof. Still muted.
Okay,
There
we
go.
go. So with regards to what I referred or described very briefly just now about warrants and convertible loan agreements. So I will just go into a little more in-depth view of what warrants are. Okay, so basically, if you buy a warrant, you buy a right to, in the future, buy a share to a certain price, which we agree on now. So basically, at this point, I buy the warrant. At this point, which may be 1 or 3 years later, I have the right to purchase a share if I can show that I have this warrant. And I can buy that at the price that we determined 3 years ago, which might be or might not be cheaper than the market value of the share. So if I'm an investor, I would have obviously like this price, the market value, to be way higher than the price that we agreed on, because that means that I'm paying less than the market value. So the problem with the whys, which means that I, as an investor, provide equity to a company by buying a certain amount of shares, a certain amount of options, which I later on will turn into shares if the price for the shares at that point is more expensive than the price that we agreed on. The problem is that we do have to agree on a price when I'm buying these warrants. And a convertible loan agreement, in the scenario of a convertible loan agreement, we do not have to agree on this price, because a convertible loan means that I'm giving you a certain amount of money, and given a certain event, perhaps a new investment round to a certain valuation, I will convert this amount of money to shares. And the price, the valuation or the conversion rate will be determined by what the other investors are paying. So we don't have to agree on what the conversion rate will be at this point. That can be decided by the other investors. So with the whys, I have to agree now on the valuation. That's the big difference. So yeah, the obvious side up, or the obvious benefit of using the whys, is that it's not a debt on the balance sheet, whereas a convertible loan will be a debt on the balance sheet. So those are the main alternatives, if we're not, of course, taking into account the most common way of raising equity, which is just a share issuance.
Exactly. And so a little bit about the process and the paperwork. So as a general, just a disclaimer, please note that this does not, the points here, they do not follow a chronological order. It is very common for things to happen simultaneously in a investment process. But usually it starts off with, as you all know, with some questions, discussions internally, and also with the investor. It is always good to start off by having a cap table. So a cap table in which your current shareholding is presented, and also a cap table of the planned shareholding. So how much should the investor actually own after the investment? And we will be talking a little bit about this more in depth later, but a term sheet is always a really good document to have. Why? Because it shows that you are acquainted with investment processes from a legal perspective, but it also sets the frame for the upcoming process and negotiations. I will be mentioning that a little bit later on, as I said. After that, or usually simultaneously, there will be a due diligence process. And basically, a due diligence process is a FBI investigation of your company. And what the investor usually does is go through all your legal documents and also financial documents. But as a lawyer, I will only be mentioning the legal due diligence. And what is actually the purpose of the due diligence? Well, it's for the investor to identify any risks in the company. So it can be anything from potential or ongoing disputes. It can also be, depending on the company in question, it can be the question of environmental questions, tax questions. And so what does the due diligence usually result in? Well, either it will affect the pricing or the total investment amount and the warranties, of course, but we will be speaking about that later on as well. And now I just mentioned a little bit about the next point, which is the negotiations. Usually, after the due diligence has been completed, you will be landing in a sort of agreement in which all the risks are disclosed depending now on which agreement you decide to go forward with. So investment agreement, convertible loan agreement, it depends. But that's usually what the process looks like, and it ends with a signing and a closing. They can occur simultaneously in a classic M&A process. If you, for instance, have this is a bit not to the topic, but if you, for instance, have a real property in a transaction, the closing usually takes part after. And if there are also competition law perspectives to take into consideration, the closing is usually later. So not simultaneously with the signing, because usually the competition authority has to grant its approval.
Gabby, can I jump in with a question?
Yes.
So first, the term sheet, like how is that triggered? Is it normally the investor initiative, or is it like the lead investor, or can the entrepreneur bring a framework? Comment a little bit about that, and then also why the signing and the closing, like what's closing? Is it the money on the bank account, or yeah? So please elaborate a little bit.
Yes, the term sheet I will be speaking about in a little bit more detail later on, and I will actually be answering your questions then. So I'll jump straight into the signing closing. The signing, I could also talk about this for a couple of hours, but usually, for instance, taking the real property example, you can't, usually in Sweden, you have, for instance, there's a document called lagfart, which you have to send in to the authorities to register the ownership. And under Swedish law, you can't enter into an agreement agreeing to buy property. So usually you have, in such case, so you pay a down payment in such case, And then once the lagfart, so this document has been registered with the authorities, full payment is received. However, why I talked about this example is to make it a little bit more simple. As you can imagine, there are usually other parameters besides real property that are relevant for a transaction or investment process. For instance, if you agree upon a price, maybe you as an owner know, hey, I know if I get this investor, our business will explode. Maybe the investor also knows this, but it's not during the time of signing the agreement. That's not the case. It will happen afterwards. So you can also push the closing to a couple of months to see how the business is going and get more payment after that. This should not be confused with the tilläggsköpeskilling, which is like an additional payment, which is, there are different mechanisms. But basically, signing is, if you're imagining buying an apartment, you go to the real estate agent, you sign, yes, I bought the apartment, but there are some formalities that need to be taken care of in between. So this is usually what signing and closing, why they're separated, but also to do with the pricing mechanism. That was a short description of the signing and closing. But if you do have any further questions about it, I'm happy to talk about it.
Yeah, let's if anyone else have questions as well, there will be a short Q&A afterwards. Thanks. Move on.
Yes. So let's talk about the paperwork.
Yeah, let's just go briefly through the paperwork. So we have not always, but sometimes an NDA. Perhaps you're a company which are not really comfortable with providing any documentation at all until you have signed an NDA. So if you're a tech-heavy company with a lot of IP, you might not be comfortable with disclosing your patent directly, or even your new idea. So then you might draft what is called a non-disclosure agreement. In Swedish, it's a sekretessavtal, just to make sure that no information that you are giving the investor is transferred to third parties. So that might be the case, but we often do not use NDAs because this point of secrecy, or the NDA itself, is often covered under the term sheet. And like Gabby said, term sheet is the first kind of paper you have in an investment round, and it's not binding. It's just to show that, okay, what terms are we going to regulate in the rest of this investment process? That's the only sort of function of the term sheet, and it can be presented by the investor or the founders. It's either way, basically. And then the next in step would be the convertible loan agreement if you're raising equity through a convertible loan. If you're not, then obviously you're not going to have a convertible loan agreement. So NDA, if that is applicable. Number two, the term sheet. Number three, either convertible loan agreement or subscription and shareholders agreement. The subscription agreement regulates the investment. We will use the term investment agreement interchangeably with subscription agreement. So the subscription/investment agreements, they just regulate how much money are you going to pay me, how many shares are you going to get, what warranties are you providing as a founder, and how much money can I claim from you if this is not correct. The shareholders agreement regulates the ownership in the company after the investment. All right, so that's briefly the paperwork, and Gabby will move over to just talk more in depth about the term sheet.
So a little bit about the term sheet. The term sheet is usually a letter of intent. So what is a letter of intent? It is what the parties intend to do. So I would say the benefit of having a term sheet is that it makes the process, one, foreseeable, two, efficient from a cost and time perspective. Because once you start the process and negotiations, you already know what the really, really relevant provisions are. What are the conditions of the investment? If you've already established that, there is no need to, as the process goes on, go on to discuss these things, since we have agreed on this. So what about if you change your mind during the process? That leads us to the next question. Is a term sheet binding? Usually not, except for, as Olof mentioned about the NDA about not disclosing any confidential information about the other party. That should of course be binding, because as the negotiations goes on, you will be disclosing very sensitive information with each other. So that is absolutely binding. It should always be binding, actually. And also the governing law clause. Swedish law, I would recommend. In Sweden, there is actually no, except for real property and other types of agreements. In Sweden, you have the freedom of contract principle, which means that you basically can enter into an agreement. It would be legally binding to enter into a convertible loan agreement orally. But why wouldn't you do that? Well, because of evidence questions. If you were to disagree, how would you be able to prove what you actually agreed on? So the term sheet is a first document of proof also about what you've been discussing. And it is not necessary, it's not mandatory to have a term sheet. As I mentioned, freedom of contract under Swedish law. But from a startup perspective, it gives you the upper hand in the negotiations. It shows the investor that you are well acquainted with the process, you are well aware of the legal documentation that is necessary, and you also know what terms and conditions you're willing to include a third party into your company. And to relate to Sebastian's question, it is common for investors to bounce over a term sheet, because usually they have standardized documents in-house, which they usually just fill in and provide the startup with. But it's always, as I said, it shows that you're well acquainted with the legal stuff, and also gives you the upper hand if you have your own term sheet. And please note that you don't have to use a lot of legal mumbo jumbo. I've read term sheets that basically consist of bullet points also. So it's just to set the scope, basically. And like I said, instead of investing time in negotiating the price and as the due diligence is going on, it actually makes you focus on the bits that you actually need to focus on. So it sets out the framework, sort of a guidance in the dark, I would say, a torch. And now we're going to talk a little bit more about our favorite agreement. Not yet. This is an example of a term sheet, by the way. This is actually based on an actual case. It's a very simple term sheet. As you can see, a lot of things have left blank, but this is usually the most important things, the things that are blank or in brackets, is what you should focus on. So if we just read that a little bit. Yeah, and we will also be talking about this notion of founders, as you can see there. Olof will be talking about vesting provisions later on, which is very relevant for startups. But now we will be talking about our favorite type of agreement, the convertible loan.
Okay, so given that you're not raising equity in the sense that an investor is paying you money right now and you're giving shares right now, then the main alternative, I would say, would be convertible loan agreement. So this means, as I've described earlier, that you receive money from the investor and this money may be converted, but I will go through this more quickly in respect of time, and there's just a certain amount of regulations which you need in a convertible loan agreement. The first is obviously, so what should trigger conversion? If I'm paid a certain amount of money, how will the investor know that it's going to be converted into shares? What event is going to determine that? And a very clear-cut example is an evaluation, an investment in the company made pursuant to a certain evaluation. So if I'm an investor, I pay a certain amount of money at the evaluation of maybe 20 million to the company. Then I want my loan to trigger conversion if the company receives money at the evaluation of perhaps 50 million, because then I will get a discount in relation to what the other investors are paying, and often 20% discount, that's customary. So it's when it shall be triggered, it's what the discount is, and also what kind of interest is running on this loan, because often the conversion will be including interest, but the interest will often be symbolic. So maybe 1 to 2%, sometimes 4 to 8, but many times it's between 2 to 4 when I write these agreements, at least. So we can move on to the next slide. So the first, this is basically just a very easy example. We have an amount that is provided to the company, and it shall be paid at a certain date to the company. And there's a maturity date, which sometimes is called a long stop date, which means that if no trigger event, let's say a round made at a certain evaluation, has been, if no such event has been triggered at the given date, which is say 3 years from now, then I shall receive my money back. But it's not a guarantee that the investor can say, hey, I want my money back. Sometimes, and that is depending on how the negotiations are made or done, sometimes the company can say that, well, if we reach this date, then we shall have the right to either pay you in shares at whatever our evaluation is at that point, or pay you back the loan. So it will be up to us. Or maybe you can have this reversed rights, but for the investor. It's all depending on how either good you are at negotiating, but also what your power position is. All right. So that's basically it about the convertible loan agreement. So let's move along to the investment agreement, which is a very interesting agreement for founders, because it puts a lot of pressure in terms of liability, which a convertible loan agreement does not. Remember, a convertible loan means that I will, at a certain given time, when a future investment is made, then I will jump along with those investors. So I'm not making a due diligence. I'm not conducting such a process. The investors later on will be doing that. But if I'm putting money into the company now, and I receive shares in the company now, then I would like to know exactly what am I getting. Am I jumping into any problems here? Is there any ongoing disputes in the company? No taxes which haven't been paid, and so forth. As an investor, I would like to know that. So basically,
sorry to interrupt, Olof. We have 15 minutes left for the presentation.
Yeah, perfect. Thank you. So the first thing you can, as a founder, just ask yourself is, do I need all the money now? Or can we divide the investment up in several tranches, right? Do I need 1 million in turn for 10% of my company now? Or can I take 5 million in turn for 5%, and let's just review and see how this relationship is going, and let's then talk about the next tranche later. That's one thing to ask yourself. And then also, what I think is the absolutely most important part of the investment agreement, which are the warranties. So normal warranties would include that I, as a founder, I warrant and I guarantee that this company is not in an ongoing dispute. I guarantee that we have no unpaid taxes. I guarantee that we own all the intellectual property needed in order for us to run the company. All those things are very customary to guarantee. So, and the remedies are supposed to reflect these guarantees or warranties. So if I'm in breach of a warranty, then obviously I should pay the investors, right? Because I've been lying about the company and they've given me money. So the important part to assess here is, what can I really guarantee, right? Am I okay with guaranteeing that we have no claims directed towards us? I don't think so, because I don't know if we have a claim. Perhaps I don't know if we have a claim directed towards us. I can guarantee that we have no ongoing disputes to the extent of my knowledge, but I can't guarantee that nobody has made a claim towards me, right? So very, very important to assess, what can I warrant, because you will be held liable later on if you are in breach of these warranties. So let's not go do the example, because I already made an example. Let's move forward to the shareholders agreement. Stage is yours, Gabby.
Thanks. Well, a shareholders agreement, as it's by the name, it's an agreement between the shareholders of the company, and it's usually negotiated simultaneously with the investment documentation. And so, since we have a limited amount of time, I'm just going to quickly dive into some key aspects that are usually found in shareholders agreements and that are standard, I would say. So the first point here, the right of first refusal, in Swedish it's called a förköpsklausul, basically, and it is also possible to insert that into the Articles of Association. Articles of Association take precedence over the shareholders agreement. Do remember that, because the Articles of Association is the company's document. And what did I say about the Swedish Companies Act? It is mandatory, and you cannot deviate from certain provisions. The shareholders agreement is only binding between the shareholders. And what does the first right of refusal mean? Well, it means that the seller is obliged to offer the shares to the other shareholders before selling to a third party. And then, similar, but not exactly the same, we have the drag along clause, which I usually, to keep it separate from the tag along, I usually connect the drag along with the word force. So basically it means that if the majority shareholder, if shareholders of a company sells their shares, the remaining minority shareholders should be obliged to join the deal, so force. But they must, of course, be offered the same terms and conditions as the majority shareholder. So they're dragging, the majority is dragging along the other shareholders. In turn, the tag along allows the minority shareholders to tag along after if a sale of the shares is taking place. But also to the same terms and conditions. And let's talk about the decision making, which I actually would say is the most important thing to discuss when negotiating a shareholders agreement. Usually one talks about a veto catalog. And based, or depending on how the final cap table will look like, and if there is a majority investor, or if there is, for instance, a fund, there might be certain decisions that such a major investor or wants to, in decisions that that company wants to take part in, despite the fact that they're not actually per se a majority shareholder. So basically what a veto catalog or decision-making catalog, it aims to sort of deviate from the Swedish Companies Act's standard rules on decision-making, which you actually can deviate from. And what kind of decisions should be subject to this catalog? Well, here you have standard, what the most common ones. So of course, the amendments of the Articles of Association, which I mentioned, have priority over the shareholders agreement. The Articles of Association usually have a the core of what the company should actually be doing. So if you want to amend this, of course you should perhaps have 90% should agree, or maybe all parties should agree. But as you can see, there are several types of decisions that you should consider, not sort of leaving your power or giving too much power to investors, since it actually is your company. But Sebastian will be sending out this presentation later on, so you can have a close look at this catalog and let us know if you have any questions on that. But I think you're actually more interested to hear about the next slide about the vesting. So that's why I'm going to leave the floor to Olof.
Okay, so there are certain conditions, of course, in the investment process that are more interesting to you as founders than what they would be for a big company, or than what they are for the investors. So for the purposes of this presentation, which is meant for you founders, I would say that there are a couple of interesting things that you should pay extra attention to. One of them being what we talked about earlier, the liability and warranties in case the warranties and liability in case of breach of warranties. And then one more of these things that are extra important would be the vesting provisions, which means that basically I, as a founder, have to keep working in the company in order to successfully gain or acquire the right to my shares, which I already own, but the investors would like to see that I stay in the company for a certain amount of time. So this is pretty obvious. So if an investor is putting good money into a company, then perhaps the whole value of the company is the founders, right? The team. So the investor wants to know that these people will keep on working even after I put my money in, or otherwise my whole investment will be useless. So how can we force the founders to do this? Well, we can say that once every year you will gain the right to say 33.3 whatever percent to your shares. So if you were, let's make it easier. So once every 5th year, you will gain 20% of your shares. So if you were to work for 3 years, you have basically acquired the right to 60% of your shares. And if you were to leave the company after 3 years, you would have to sell 40% of your shareholding to the other parties of the company at a substantially lower value than the market value. So I've seen cases where it would be the quotient value, which is often a couple of kroners. So it could be a really harsh regulation. And if you, let's say, work all the 5 years in the company and then you decide to quit, well then you still might have to sell your shares, because that's pretty standard in a shareholders agreement, but you would have the fair market value paid for those shares. So that is what's called vesting. And then you would also often deviate the term good leaver from the term bad leaver. So if I get permanently ill after having working 3 years, is it really reasonable that I should sell 40% of my shares for a couple of crowns? No. But if I were to voluntarily quit, or I come drunk to work and punch the CEO in the head, well, and get fired, then perhaps it is more reasonable that I have to sell my shares to a lower price, right? And the put option, let's just do that quickly. It's not something that you see very often, but sometimes an investor would like to have the right to, if they feel that this company is going down the shitter and we're looking at a pretty bad scenario, I don't want to hold any shares in this company, then I, as an investor, should have the right to sell my shares to you. I have the right to sell shares to the rest of you for a very, very small amount of money. And this is, of course, because if they were to sell the shares, the other people or owners in the company might not even want to buy it because the company is going so bad. So they want to have the easy exit, to force you to buy their shares so that they can leave. Is this, was it 1445 we had until?
You have 3 more minutes, actually.
Okay, that's good. So this is one example that we can read, that provided that the founder continues to work for the company according to the employment agreement, obviously you have to connect the fact that you have to work to a certain kind of agreement, or at least you have to put a parameter. You have to work 40 hours a week or whatever. Normally you put it in the relation to your employment agreement. So you have to work in according to your employment agreement, and provided that you do so, 1/36 of the shares will be considered vested shares at the last day of each calendar month. So monthly vesting, this would be called, as opposed to yearly vesting. And the shares are not vested, the shares that are not vested will be considered unvested. So you can jump to clause 4. It says that if the founder terminates the employment agreement during the vesting period, any and all unvested shares shall be offered for sale to the other parties to a purchase price corresponding to whatever valuations you would like to use, right? But if you voluntarily quit, then you most likely get the lower valuation. If you become permanently ill, then most likely you will get the better valuation, right? And there's a lot of variations to this. So this is not in any way sort of a set example of how it always is. There's a lot of variations. That's basically it, I think. And you're free to ask any questions, of course. There's a lot of questions to be asked, I think.
Yeah, thanks so much, Gabby and Olof, for a very, very important and valuable session. Many of those things are key to actually building your company and acquiring more customers. But at the main time, before you can actually make your own money organically, you need ways to finance the future. I have 2 questions, but I'm gonna also ask the others to have, if there's any questions, then that's prioritized from you. All good? So then I'm gonna jump in with the. We talked about vesting, right? How common is 1-year cliff in Sweden? Meaning, yeah.
So I would say that it is not uncommon by any means, but I wouldn't say that, oh, it's half and half or any. I have seen a couple agreements with 1-year cliff, and it really depends on which kind of agreement we're talking about. Because if you're an employee in a company and you have acquired warrants and you're vesting the warrants, then the cliff, if I would say, is more common than what I see in in shareholders agreement between investors and founders. That's for the most part I see monthly or yearly vesting without cliffs, actually.
Yep, got it. My second question is, this is a quite structured process, right? And
Right.
the bigger the rounds, the larger the investors, the more institutional, the more structured, the more paperwork. Like where do you draw the line from when like you go from friends, fools, and family, basically just say whatever, and then you get the angel level, it gets a little bit more structured, and then the seed round, and then the Series A. Like, could you elaborate a little bit about, from a legal point of view, what tend to be the differences in those type of rounds?
Absolutely. And I think that there's a difference between what are the changes and what should be the changes or differences between these forms of. The normal thing we see is that families and friends, and even in relation to angels, you basically skip all the documentation except for the bare minimum, which is, hey, we're issuing this amount of shares, we need this paperwork in order to register the issuance. That kind of paperwork is taken care of. But you have a shitty, badly adapted shareholders agreement, which you downloaded from, say, Startup Tools, and it's like, that's a very common way, something we see, that people download templates, they try to modify them, but they're really badly adapted for the purpose. So when you're gonna have to have a good shareholders agreement, I think, in order to promote your company and show that it's a company which taken care of, because that's what you want to show an investor, is that you have a clean company with value that you have continuously built upon. So if you show the investors that you have a template from startup tools which is badly adapted, it's not going to be very good marketing, because it shows that you're not really taking care of your company. A shareholders agreement should be basically the most important document regulating the ownership in the company. So I would say the differences are very big. There's huge differences. When the institutional investor comes along, they have a package, they show you the term sheet, they show you a template which you can build upon, or which they will build upon and adapt it to the investment process. And if you compare that to friends and family and angels, I would say that some angels are serious and they will want you to do the investment process properly, with the investment agreement and shareholders agreement being redrafted and very customized for the investment process. But that's not always the case.
Got it. Speaking of templates, it's very, very common that startups use the free templates that are online. I remember last time we talked a little bit about that, but I would love to hear, like, this is like, obviously as a legal rep, from your point of view, the free templates online are could be your worst nightmare, because they might not be adapted as well. But for a company and from an entrepreneur point of view, there's no money to pay for legal advice to tweak them. You just have to do some dirty tweaks sometimes. Like, where could you comment
Right.
on that a little bit?
Yeah, sure. I mean, the thing that I think often you would say that we don't have the money, and perhaps you do, but you don't want to pay the money. That's one scenario. The other scenario is you actually don't have the money. Let's say you actually can't afford to have a lawyer help you with this. Then the most economical way, I would say, is to download the template, send it to a lawyer and say that I have this amount of money, this is the hours you can put on this, and please tweak it to the best of your ability given this amount of time. And then as lawyers, we will try to use the time that we have been giving to focus on the main points, but with no warranty as to whether this is going to be a good agreement or not. But I don't know what you think about this, Gabby.
I agree. I would say it's like buying a pair of running shoes online from a brand that you've never used and you're intending to run a marathon. It works, but it might sometimes actually cost you more than it gives. You should always, depending, just like a running shoe, if you're aiming to run fast or long, you should always adapt your running shoe to the situation. And if you decide to use startup docs, consult with a lawyer before to just get heads up if it's okay or not. Just like you would go into maybe a shop to try the shoe before you actually buy it online. If that was, no, I like metaphors, so yeah. if that makes any sense.
Yeah, of course, it's always a trade-off.
Yeah.
And the long-term perspective that you're taking here is sometimes in a scenario when you're in a fundraising mode, the longest horizon you could ever imagine is a month or two out, right? Because you don't know if the company is going to survive. So sometimes it's really hard to think that have that type of mindset to look into the future that way. But it's really good to get your perspective on that. How often do you see issues for startups when they've used these templates, and what are the most important aspects of the templates that should be like? What's the warning signals?
Right. So the main problems, I think, is that the reason to why you have an agreement is that you have an understanding together with the counterparty or the co-parties or whatever you want to call it, and if you deviate from this understanding of this agreement, then the other party should be able to take action with this document as sort of guidance, right? So I've seen agreements where founders have agreed on certain activity requirements, which they obviously haven't read through and which they don't even want to put on one another. So it says that you're supposed to work full time, and if you don't, then the next day I shall be able to buy all of your shares for nothing, and all those kind of regulations, which are harmless in the sense that the other party would, I don't even think the other party knows they're there, and they would never invoke them. But it seems messy and unnecessarily complicated. So if you have an understanding with your co-owner, then and you print this document saying all kinds of things which are not even true, that will not be a problem until the day when you no longer agree with each other, and one of the parties perhaps get legal help, says that I want this guy out, blah blah blah, can you look at this agreement? And there's 3 or 4 different ways that you can be outed from the company, and you never even knew they existed because you never knew that you had taken these undertakings, right? I don't know, do you have any input, Gabby?
No, I would actually agree with you, and like why we decided also to talk especially about the safe. So considering your question, Sebastian, in my work, I have encountered several safe agreements which have been sort of tried to be adapted to Swedish law, and it has actually resulted in quite extensive amount of additional costs for the startup to just adjust the safe. So it's better always to just, before you go ahead, just sort of check what should we actually be doing instead of just copy pasting, because damage control can actually be way more costly.
Yeah, those are good answers. So basically, tread careful if you're using templates. It could be really beneficial, but also extremely harmful unless you think it through.
And I mean that they work as long as you're friends. But I mean, all agreements work until you're no longer friends.
Yeah, for sure. I don't have any additional questions. I know we're running out of time.
I would like to share a quick poll. There are only 3 questions, but it just helps us with feedback for our next question. So I'm going to launch it now.
Cool. So thanks for giving us some feedback. While thank you for that, Kat. I forgot about that.
No problem.
We had a prior session about intellectual property and such. Like how often in startup land do you see patents and IPs involved in those processes? It feels like it's mostly unpatented technology, right?
Yeah, mainly because code, which is basically what everyone does right now, it's governed by copyright law and not by patent law. So that's the main reason why you don't see too many patents. And also because startups very often can't afford to search. It's a very expensive process, and we can't help with that. There is often specialized, such as AWA patent will help you with that, but it's an expensive process and not necessarily very common in relation to tech-heavy companies that are working with apps, which everyone is doing right now.
All right. Anything else? I don't think we have any other questions. Olof, Gabby, many thanks. Really good to see you guys again. It's been a
Thank
long
you for
time.
having us.
Yeah, very much. Thank you.
Our pleasure, and see you guys soon. And have a great evening.
Thank you.
Bye.
You too.
Thanks.
Bye.
Thanks for joining. Bye.